Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. I want to go back to something we tackled earlier in the program, but we have an expert and a former practitioner coming up next. So I'm going to get his opinion on it. Silvana Taveras, the alderhuman, testifying in the CCPSA confirmation hearing, directing her comments to Anjanette Young, who was name was put forward for this civilian police accountability board. I mean, that's the way it's pitched. Anjanette Young was the victim of a mistaken CPD raid a couple of years back. Was a cause celeb of Kim Fox's for discussing police misconduct, essentially. This is what Taveras had to say, though. Anjanette Young was wrongfully, her home was wrongfully raided, and so she deserved justice. There's no question about that. Police do make mistakes, and you got to own your mistakes. Fine, but it doesn't make her any sort of particular expert on policing or public safety. And Taveras was quick to point to some comments she made that would suggest quite the opposite, in fact. On the Dexter Reed case, the attempted cop killer who shot a cop, opened fire on cops, and the city was ready to make a settlement with the family.
Recently, the city council denied a proposed lawsuit settlement for the estate of attempted police murderer Dexter Reed. In that incident, Reed shot a police officer. Mm-hmm. You were quoted in an interview with WTTW calling police returning fire excessive. With the statistics telling the truth, and as we prepare for an officer's funeral on Friday, I don't think that this is the perspective of somebody who can be objective. You're before the committee today seeking an appointment to a commission born out of the same movement that also saw the skyrocketing of attacks on police. Since its creation of the CCPSA, the commission has mostly pushed efforts to restrict officers, despite data showing more violence is done to officers, not by officers.
For reaction to that and discussion on a number of other issues, please be joined by Bob Milan, former First Assistant State's Attorney for Cook County, former Assistant U.S. Attorney in the Northern District of Illinois as well. Bob, thanks for joining us again. Appreciate it.
Sure, Dan. Always good to talk to you.
What about what Alderhuman Taveras had to say about the CCPSA, the genesis of it, the utility of it, and, of course, the backdrop of this is all the increase in violence directed at police, as Taveras mentioned, since the George Floyd riots?
Oh, she's right about the statistics. The statistics do bear out that there's far more violence directed at the police than they do towards anybody in the public. And if you look at this years, the amount of police shootings where they were put in a position where they had to fire at somebody have gone down. And so that's all positives. And at the time that we're dealing with right now with the death of Officer Bartholomew and his serious injury of his partner, we should be doing everything we can to back the police operations and not criticize them.
The Cook County State's Attorney, Eileen O'Malley, Madigan, Cullerton, Burke, big Irish name. She sort of has largely skated on culpability here. We're talking a lot about Judge Like, talking about the case involving the criminal who shot and killed Bartholomew and his and seriously injured his partner. And cases like that, where you have basically the Safety Act striking again and again and again against whether it's law enforcement or innocent civilians. Bethany McGee comes to mind. Eileen Burke has sort of not been focused upon. We're talking about the politicians, which is fair. Talking about the judges, that's also fair. But there was a piece earlier this week at CWB Chicago where some defense attorneys were interviewed, and I said, it's fine for criticism to be directed at the judge and the pretrial detention decisions that are made by Cook County judges. But, if Burke's office disagrees with a judge, for example, releasing a repeat violent offender under whatever theory, but, with the Safety Act as cover, they do have some remedies they can attempt to apply. They could seek a motion for relief, I should say, essentially for reconsideration of, for example, a judge's decision to release a prisoner release a suspect on electronic monitoring. They could also take the matter to an appellate court under Supreme Court Rule 604. And those tools, according to the CWB analysis, have rarely been used by Eileen Burke's office, including in the case of Talley, the man who is charged with killing Officer Bartholomew and seriously wounding his partner. So does the state's attorney deserve some scrutiny here and questioning about why they're not pressing judges harder with all of the tools at their disposal?
Let me just start out by saying that at the actual hearings on Talley and other high-profile cases, clearly the assistant state's attorneys are making very strong to keep these people locked up and detained. I've been impressed, by the assistant state's attorneys in court making the records. But to your question, yes, more can be done. All of these decisions to not detain are appealable, and I don't think there's ever been a single appeal filed on any of these over the years, and that has to change. The other thing that's important.
There's been a few, according to CWB Chicago, but I mean it's very few considering how many stories we have week after week of people on pretrial release for a violent crime committing another violent crime, and that's the issue. So yeah, that's where we're going.
Yeah. And so it has to start. You have to start doing it, because what are you doing? You're setting a pattern. You're setting an example throughout the court system that we're not going to take this anymore on these kind of cases. I mean, the Talley case is a perfect example. There was no appeal filed that I'm aware of, or a petition to reconsider, and so pulling these out on the street. So that has to change. And the second thing is, I would hope that the elected state's attorney of the biggest county in the state of Illinois would take a position on the Safety Act. I mean, she's been totally silent on it, and she is the person that deals with it the most. And we would hope that she would stand up with others like me and say, let's amend the Safety Act right now. I mean, we're not calling to throw it out. We're calling to make logical amendments to this so it is safe for the streets. Because right now it's a danger act. I mean, it's intentionally releasing dangerous people on the street. It's putting judges in a position where they cannot consider criminal backgrounds on many cases. They can't even consider a guy's criminal. And so they have to let these guys out. And it's what it's done is it's encouraged judges like the judge in the Talley case to let dangerous guys out. So I would hope she'd stand up and take a position on this, because I haven't heard her take any position on it.
Why suggest amending it and not just repealing it outright?
I'm sorry, what did you say?
Why would you? Why suggest amending it rather than just repealing it outright?
Because I think you have to be realistic. I don't think that's going to happen in this state.
No, I understand, but you stake out the ground
the amendments I'm taking. Well, because be realistic. I mean, you're not going to. I don't think most people even care about the cashless part, right? I certainly don't. This could be a very good act if you make about 4 or 5 amendments. You know, you allow judges, you give judges discretion to hold everybody from a Class A and up based on a charged crime and their criminal background. You don't require prosecutors to have to file petitions to detain. Experienced judges should be able to hear the facts, hear the background, and make their decision on their own. You make it so that you amend the act to allow judges to detain a defendant if he violates his conditions of release, like doesn't appear or drops hot on a drug test. They're not allowed to do that. You do statewide for these judges to enforce the importance of protecting the public from lawless offenders. And then unrelated to this, but somewhat related, is you got to end this electronic monitoring. It's not working, right? It's not working. So,
right.
And if you did that, this would be a pretty good act.
Well, so in other words, if you if you gutted it, it would be a pretty good act. I mean, so I guess that's my point.
You could say that's gutting it. I guess you could say it's gutting it. I mean, that's there's degrees, but look, here's how it was pitched to us, right, Dan? It was pitched to us. A millionaire can get out for a case, but a poor person can't, right? Yeah. So that's how it was pitched to the public. So we have to end cash. We have to take money out of it. All right, let's take it out. But don't do all these other things that it did. And so let's face it, the governor has to wear the jacket for this. I mean, Bartholomew's dead, and the other officers probably paralyzed for life. The governor and the speaker and the head of the Senate, president of the Senate, they gotta wear the jacket for this, because they're the ones that put this in motion and got it signed, and that's where we're at.
Absolutely right. Absolutely right. And that's something else that Eileen Burke and others should be saying. Let's start. There's a lot of responsibility to go around, but let's start at the top. Because the thing about it is, you still have these judges, though. Like, if I could, in the Talley case. I mean, the things he said, according to the court record, are akin to what Tim Evans used to say about, the prefrontal cortex is not fully formed until the age of 26. So, he looked at this cop killer's record of violence and disappearance, and said, well, he's got a kid now. I think he's matured from when I saw him in court the first time a couple of years back, even though he had committed all these offenses in the intervening period. And so I'm going to roll the dice with him because he's not, his mental, capacity isn't fully formed. He's only 25 at the time or something like that. I mean, that kind of judicial philosophy, to be generous, is an anathema to public safety. I mean, so there's also a problem with accountability from by the chief judge with respect to judges if we're going to be serious about public safety too.
Oh, absolutely. Look, no one can tell me that they're not being told. Judges aren't being told by the powers that be to release these guys. Nobody could make a decision like that. If you brought 10 common citizens in, not even lawyers in, and they heard these facts, 4-time convicted armed robber, convicted of attacking a correctional officer, possession of a stolen motor vehicle. Now he has an armed vehicular hijacking and an armed robbery, and you're going to let that guy out?
I know.
No one can tell me. The 10 people on the street would have said, no, we're not letting this guy on the street. But a trained judge in Cook County does that, right? Why? Because they're being told to do it. This stuff he said about the brain and all that, he just said it. The reality is he's being told. His quote, and this is how we know that they're being told this, and this is how we know that the Safety Act is causing this. His quote where he says, under the state's old bail system, Talley would have faced $1 million bail. However, our esteemed legislature says, no, we're not going to do that anymore. We're going to make judges take a critical look at it. Did he ever? And now we have a dead police officer, 37, 38 years old, another guy in critical condition, all because of this nonsense they're being told. It makes me sick.
So, I mean, when you say they're being told, are you suggesting it's sort of one of these things, everybody knows what to do, so nobody has to give the order? Or are you suggesting Chief Judge Beach is telling his judges, this is what you're going to do?
This started before Chief Judge Beach was named. Now this
Well,
started
that's true.
when this act. So this is coming from the Black Caucus. They pushed the Safety Act. This is coming from the powers that be in the Democratic Party. And look, how do you if you're a judge, how do you get on the appellate court? You make these guys happy. How do you get on the Illinois Supreme Court? You make these guys happy. You don't make waves. You do what you're told. And what results in that? When you're worried about your own future and good things happening for you in the future, you end up with dead citizen. You end up with a girl on fire on the CTA. Her life is ruined. You end up with a dead Chicago cop. We could go on and on. If this doesn't change now, it's never going to change.
Yeah. Well said. Something else I wanted to get your take on. This is, I can't say it's surprising. Kim Foxx. Kim Foxx said in a deposition last month she personally believed two men who were exonerated and whose certificates of innocence were not opposed by her office when she was state's attorney were in fact guilty of a, quote, the, quote, heinous act of murder for which they were convicted. One of the two men reached a wrongful conviction settlement with the city of Chicago, so large, meaning it's more than 100,000, it's waiting city council approval. The man accused of being his accomplice is preparing to take his lawsuit to a federal jury next week. There was a cop who had been basically found to have committed misconduct, but and I don't need to get into the details of the case. The bottom line is she believed, despite what the police officer, the investigator in the case did, that these guys were guilty, but she didn't oppose the certificate of innocence. She basically walked away from it. And there's another case. This was back in her city club speech where she announced that she wasn't running again, where she suggested a woman who was convicted for a crime that she didn't commit, but she hadn't, and the woman was in the audience and she had said something to Kim Foxx before her city club speech. But Kim Foxx says in the deposition under oath, she had no basis to make that statement. She didn't know the facts of the case. And under additional questioning, the attorney asked, so did you basically just repeat what she told you and accept that as gospel? And she said, yeah, you could say that. So we have people that, one, she thought were guilty, and she turns a blind eye to their exoneration and now payouts by the city. And the other, who also has a civil suit against the city, she just repeats publicly her version of events, such that now that woman suing the city, saying she was convicted of a crime she never committed, is using Kim Foxx's words as evidence in her civil trial against the city of Chicago. I mean, are you telling me there's nothing that can be done with this kind of behavior by a former Cook County State's attorney?
Yeah, well, let's take the first example. The office did oppose the certificate of innocence for 5 years and then suddenly changed their position. And it's important for the people to understand what the law is for certificate of innocence. It's not complicated. It's now the burden shifts. So in order to get a certificate of innocence, the offender has to prove that they were actually innocent of the crime they were charged for. So they have to prove of the evidence that they were innocent of the case they were charged with. There's a difference between finding them not guilty, which means the state didn't meet its burden, and actual innocence, which means the guy didn't do it, right? There's a big gap there.
Right.
And so what we don't know is what made her change her mind 5 years later. And so I'm not going to speculate. Maybe there was a legitimate reason. I don't know. But I know that under her administration, they were giving these things out like candy, right? Like, I read that they were giving 4 out of 5 out. I mean, that's insane, right? And so a responsible prosecutor has to look at this and say, all right, judge found him not guilty, or a jury found him not guilty. Is he actually innocent? If not, and you have evidence, you fight it. And that's what you do. You go to war and you fight it. And you know what? Granting of certificates of innocence have been reversed by the appellate court in Illinois. So judges have given them out. You appeal it, and they've been reversed. They said, nope, there's enough evidence there. He was unable to prove that he was actually innocent. And so, it's just important for the public to understand how these things work.
Yeah, no, and I appreciate the explanation. But in the case of the men she's testified, or that she said in a deposition, so under oath, she believed they were guilty, but she walked away from opposing the certificate of innocence. And so, I mean, is there any potential criminal legal exposure there?
No, against her? No.
Yeah.
You can say whatever she wants. The question is this. She said, I believe they were innocent, but we still granted the certificate. All right. What was the evidence? What changed in the evidence? One thing to say, I believe he did it. Did something change in your evidence? She owes the public an explanation why you would do that. Here's the other thing. These certificates of innocence get waved around in federal court and in state court, and they turn murderers into millionaires. And that's what's going on here. That's what's going on 26 in California. They're trying to turn these murderers into millionaires, and it makes me sick. And so you need strong prosecutors to take them on. You go all out. If you lose, you lose, but you got to fight. And under that administration, they weren't fighting. They were laying down and just giving it to them. And so could you imagine? And here's the other thing they weren't doing. They weren't notifying victims' families when they were dismissing cases and when they were granting these certificates of innocence. So could you imagine you lose your father 20 years ago, and all of a sudden you see on the news that the guy's getting $1 million, and you're like, whoa, nobody even called me, right? That's what was going on. I mean, it's ridiculous what happened under that administration.
Bob Milan, former first assistant state's attorney, Cook County, also a former assistant U.S. attorney for the Northern District of Illinois. Bob, thanks as always. Appreciate it.
Good talking to you, Dan.
You too. And Bob Milan joined us on the alphawealthgroup.com answer line.
The more you listen, the more you'll know. This is Chicago's Morning Answer. On AM 560. The Answer.
Hey, Chicagoland, it's Jeff from Jeff Buys Your House. If you recently inherited a property, you're likely navigating a lot right now. Loss, family decisions, and maybe some difficult conversations. And now there's a house to figure out. Here's what we've learned from helping hundreds of families since 2007. Every inherited home situation is different, and